is that I think they would have a really tough time right now trying to justify how to enforce a law that a federal judge has told them is unconstitutional.
That's lead plaintiff's attorney, David Sigale, in the case challenging Illinois' prohibition of individuals with concealed carry licenses carrying firearms concealed on public transit. It is Illinois in Focus Daily. I'm Greg Bishop. Tune in each and every weekday morning live, but also get the podcast. Search for Illinois in Focus, and you'll be able to find that. But like, subscribe, hit that notification bell with America's Talking Network. So Friday, the states did file an appeal in the case challenging the state's prohibition of carrying firearms on concealed firearms on mass transit. And this obviously is a case we talked about yesterday. It was filed in 2022, practically 2 years ago, just over 2 years ago. Makes its way through briefings, and a judge late last month declared in district court, federal district court, not state court, federal district court, that the prohibition of individuals carrying concealed firearms on mass transit was a violation of the Second Amendment. So we heard, of course, what the governor had to say. We'll hear a little bit of that. But I reached out to David Sigale. He's the lead attorney for the plaintiffs in this case. And here's his initial reaction of the appeal moving forward and what this means.
We'll continue this litigation at the next stage and present our arguments to the appellate court. But again, we believe that we're on solid legal ground, and that Judge Johnston, reached the correct conclusion and was very thorough in doing so.
So Sigale obviously ready to go to the appeals court with this. This will be handled by the 7th Circuit U.S. Court of Appeals, again in federal court, not in state courts. Earlier this month, Governor Pritzker was asked about the ruling. We heard a little bit about this yesterday.
Well, unfortunately, many of the conservative judges who've been appointed have misunderstood what it means to uphold public safety. And, we still believe in the Second Amendment. It's part of the Constitution that you have rights as a result of the Second Amendment, but there are limitations to that. I mean, just to give one example, the right to bear arms, it's not the right to a shoulder-fired missile, as one example. There are limitations on the kinds of weapons and the places that we need to. Would we allow people to carry an AR-15 into the White House? No. So it's clear that there are some misguided decisions that get made at the circuit court level, the federal court level, and I'm hoping that it'll be overturned along the way if it has to go all the way to the Supreme Court.
So again, that's Governor Pritzker talking about how he is willing to take this all the way to the U.S. Supreme Court. But the district court essentially used the Bruin precedent in their ruling, saying that the prohibition of carrying concealed firearms on mass transit is a infringement of the Second Amendment. David Sigale responded to the governor and also to the general idea that these laws, these gun control laws, keeping law-abiding people from carrying into certain places, makes people less safe. He says, actually, it's the other way around.
About 15 years ago, I remember when Mayor Daley of Chicago was commenting on the McDonald decision that allowed Chicago residents to have a handgun in their home for defense. And his response was to one of the papers, well, what's going to happen is, someone's going to get a gun, and the next person's going to get a gun, and everything is going to be settled by everyone having a gun. It's going to be the Wild West in the streets. Everyone's going to be solving everything with a gun, or however he phrased it. And that didn't happen. I mean, Chicago has obviously, gun violence problems, but the gun violence problems aren't the law-abiding people who are now allowed to possess a firearm for self-defense. And what we have here is we have a lot of people who feel unsafe on public transportation. And, there's plenty of crime. And it's not being committed by, those law-abiding people who, go through the process and training, et cetera, to get a concealed carry license. But those people want to be able to protect themselves in case something happens, because, not to sound hyperbolic about it, but they're sitting ducks if someone decides to victimize them, which unfortunately happens. So I don't see this, and I respectfully disagree with the governor and those who are taking that side of the argument that people being able to defend themselves is going to increase crime or something like that. In fact, I would hope that people who are intent on victimizing others, knowing that they have a soft target on public transportation and the stations and so on and so forth, will stop that thinking and not attempt to commit those crimes in those places, because they know that if they do, the people that they're victimizing might actually be able to defend themselves.
So, again, a conversation I had with David Sigale yesterday, getting his response to the state appealing in this case, expected to be handled by the 7th Circuit U.S. Court of Appeals. But obviously, some of the fundamental questions here deal with so-called, safe places where people aren't allowed to carry firearms. Illinois is not the only place where this is being challenged. You've got the Second Amendment Foundation filing a lawsuit looking to allow for people to carry inside post offices and postal property, saying that prohibitions, especially in a state like Washington State, it violates the Second Amendment, and they're seeking an injunctive relief in that case. So alongside the Firearms Policy Coalition, the Second Amendment Foundation, two private citizens suing the complaint filed in the Northern District of Texas, actually. So Texas has this going on. In the Northern District, they filed that lawsuit. So they say under the Bruin ruling of June 2022, if the government seeks to restrict firearms in a particular location as a sensitive place, it must prove that its current restriction is sufficiently analogous to well-established and representative historical analog. Again, getting to that, text, tradition, and history. So now we have a federal judge in Illinois, at least, separate from post offices, explicitly saying the prohibition of carrying on mass transit is unconstitutional and violates the Second Amendment. Now, the case only dealt with several individuals named as plaintiffs, but Sigale, representing one of those lead plaintiffs, he says it's going to be hard for the state to enforce this because a judge, as it is on the record right now, has said that it's a violation of the Second Amendment. Here's Sigale in the conversation I had with him yesterday.
While this litigation is ongoing, I would caution people to follow the law, because I would hate for someone to get in trouble in the interim. However, the state has an unconstitutional law on its books. The judge has declared that. So, leaving aside the issue of that the matter's on appeal, I don't think the state has very solid ground in trying to enforce that law, whether against the plaintiffs or against anybody, because they know that it's unconstitutional. And when the authorities have knowledge that a law is unconstitutional and they go and force it against people anyway, even if it's not the named person from whatever lawsuit it involves. You know, people's civil rights. That's a violation of people's civil rights in Section 1983 of the Civil Rights Act. That's, you know, when people bring civil rights lawsuits that people, you know, that the authorities violated their rights, that's what they're doing. They're bringing a claim under what's called Section 1983. And when the government knows that the law is illegal and they go and force it against someone anyway, they're potentially opening themselves up to liability. So they might disagree, fine. But the fact is that I think they would have a really tough time right now trying to justify how to enforce a law that a federal judge has told them is unconstitutional.
So I guess the word from Sigale is to proceed with caution, even though the state's law that was passed back when concealed carry was enacted. I remember putting together a documentary back in 2011, 2012 of Illinois getting the right to keep and bear arms. Hard to believe that that's 12 years ago, but if you look that up, you can find it, Gun Free Zone, the movie. So check that out. All right, we'll track this story as well for you here with Illinois in Focus Daily. Like, subscribe, hit that notification bell each and every weekday morning with America's Talking Network.